Well, I'm delighted to be able to give a comment on this terrific book by Dr. Stefan Theil, and I'd like to begin by exploring what the book actually says before offering some reflections on the themes that are in the book. So this is a very, very well-written book, which is about the interaction between public law and the world's most pressing crisis. Now, that should be enough alone to put it on your bookshelf. But beyond the topical salience, the argument is elegantly presented and extremely clear, both page by page and across the book as a whole. It drives towards a clear core thesis. International human rights and international human rights law require the recognition of a legal standard that Dr. Theil describes as the environmental minimum. And the enforcement of that legal minimum is not beyond the capacity and legitimacy of the judicial role in the contemporary human rights framework. Now, this thesis has a basis in both theory and in legal doctrine, and to some extent in practice as well. Let me set out an outline of the argument. Now, the book sets out different approaches to addressing environmental harm and degradation. And the approach that this book takes is self-consciously an anthropocentric approach. It says that the type of minimum that it envisages is oriented around the interests of human beings, and that is articulated in turn through a theory of human rights. The limitations of this anthropogenic or anthropocentric focus are noted, but Dr. Theil justifies the case. What he's doing is making the case for what he calls environmental human rights. Now, based on a theory of rights, Theil derives an environmental minimum. And this is the basic environment-related state of affairs that respect for existing international human rights law and the concept of rights itself would require. The environmental minimum is a legalistic standard, and it's a minimalist standard as well. It's not aimed at identifying the ideal environmental setting, either in general or as an instrument for human flourishing. It's rather concerned with a minimal standard. It's summarized in chapter 1, and it's expounded in detail in chapter 3. The minimum basically comprises 3 key ideas. The first of these ideas is the specific risk principle. This holds that where regulatory action or omission leads to a specific risk to a certain human right, the minimum is brought into play. There is a state responsibility that's in play to eliminate that risk. Now, that's the specific risk principle. The second key idea is to see if the action that the state would take would trip up certain minimum standards. And there are 3 of these minimum standards that the book sets out. The first is the basic legality or rule of law standards. And these standards require something that is familiar to administrative law. First, that certain established standards that are accepted by a relevant scientific community, these are non-legal and substantive standards or subject-specific standards. These have to be made binding by the courts. So if the Intergovernmental Panel on Climate Change has agreed that some action is necessary, that would be the quintessential example of this standard being met. But there are many others we can imagine. In the COVID-19 context, we can think of the conclusions of the Scientific Advisory Group on Emergencies as being another clear example.
So far under the basket of minimum standards, we have legality, established standards, and the third are what is described as emerging standards. And these are those standards and studies that are determined or supported by emerging scientific evidence. And the crucial difference between emerging and established standards is that the evidence base for them remains in dispute in the relevant scientific community. So significant debate persists over whether or not these are actually required. And I would imagine a key example of an emerging standard was when the IPCC was still divided over whether climate change was caused by human activity, but it looked pretty likely. Now I'll get into more detail a bit later about this standard because it's another element of the book that I'm going to question. So that's the environmental minimum. It's the specific risk standard and the minimum standards. the three of them that I've just outlined. So what should happen when a court is confronted with a case brought by someone who's alleging a violation of the environmental minimum? Now, being German, Dr. Tile has, of course, diagrammed this fully on page 19 of the book, so I recommend that page to anyone. It's very clear. It works very well, actually. The specific risk principle will essentially be engaged as a sort of admissibility criterion or standing criterion. Established minimum standards will be breached when the basic principles of administrative law are breached, or where a generally accepted conclusion in the relevant scientific community is disregarded. And this will lead to a finding of a violation. There's a good discussion of remedies. I think it's fair to say that Stefan favors strong remedies in this book, although there's discussion of this point. And as for emerging standards, I'll discuss these in more detail very shortly. So throughout his examination of all of this, Dr. Tile considers a range of objections to the tendency of his overall argument. He argues that an anthropogenic approach is defensible, that the courts are capable of adjudicating polycentric disputes and balancing competing interests, and that the minimalist approach is entirely defensible. We can quibble with the details of some of these positions, but I find the arguments quite sound on most of these points. I imagine, though, of course, that some environmental activists will disagree strongly, and I'll be very keen to hear those objections. Now, that is mostly the theory part of the book, but this is not just a book of theory and assembling legal standards into some sort of doctrine. In part 2, he goes on to show, through an analysis of the jurisprudence of the European Court of Human Rights, that the theory tends to fit that approach in the very large number of cases on environmental human rights issues that have been brought to the court, about 300 in total. And this part of the book is alone interesting as a standalone case study, and its methodology, I think, is fascinating. This part of the book is part of a tendency in contemporary public law scholarship to see between the two covers of a book a deep political theory analysis in one part and a rigorous empirical study in another part, each to the profit of the other. So that, I think, is an outline of the key aims of the book. I would like to raise 3 questions. In fact, the book raises dozens of fascinating questions and it answers dozens more. I'm going to pick 3 to address in the time that I have remaining. The first is the resort to minimalism in the book. So the idea of an environmental minimum finds justification from the fact that it's derived from human rights, and human rights are by their nature minimalist and high priority claims. All that means when we say they're minimalist is that they are different from what justice in its full plenitude would require. Now, I agree with that. I think it makes perfect sense. But we need to note here that the minimalism of human rights is not always so frugal. And even when it doesn't demand justice, it can demand an awful lot. And I wonder whether the environmental minimum in this book always keeps pace with those demands. So at page 13, the point is made by Dr. Tile in the following way. He says, the argument in the book is significantly narrower than requiring environmental justice. The environmental minimum constitutes an interpretation of the protections that are necessary to safeguard commitments to human dignity and autonomy in the face of environmental harm. Now, on one view, those requirements of human dignity and autonomy are not so narrow. They could require suitable air quality in London. It could require that global emissions are kept low to respect the rights of those workers who have to work outdoors. And when you speak of established standards as one of the 3 minimum standards, these can be extremely demanding. The findings, for instance, of the IPCC, much more demanding, for instance, than health or pensions interventions under constitutional social rights litigation. So asking a court to ensure that carbon net zero is met by 2050 could potentially involve giving it supervisory jurisdiction over elements of public policy that include transport, housing, building, agriculture, retail, and industrial strategy, as well as a significant portion of the Treasury's domain, namely tax policy. That is major public policy. That is potentially something that follows from a legal standard that requires full respect for human dignity and autonomy. But on the other hand, in the book, it's said at page 109 that states can avoid a violation of the environmental minimum. They are only required to provide regulations in good faith and to consistently enforce them. Now, this approach looks a bit thinner and more legalistic, less content focused. And the requirements in general of the environmental minimum are framed according to what is plausible to ask a court to enforce in large measure. Now, the problem with this second standard is that states might meet that standard somewhat easily while carrying out significant environmental destruction or failing to do anything about it. The UK, which is singled out several times for condemnation, can refer to its various plans and laws for getting to carbon neutrality. It can be very hard for a court to say or to establish that these regulations are implemented in bad faith. So, in sum, I think on the issue of minimalism, these two different approaches, a very robust form of approach, which is faithful to the idea of human rights, and a very minimal and procedural approach, on the other hand, will probably be tried out in the courts under the approach that's recommended in this book. And I think when that happens, there will be pressure for the courts to go down the latter, more proceduralist route, because the questions will be so politically contentious and legally challenging for the courts to answer. I suspect that might be part of the reason why the South African Constitutional Court and German Federal Constitutional Court have been more proceduralist in their constitutional environmental rights jurisprudence. So that's my comment on the minimalist standards, and I can see I only have a few minutes left, so I'm going to talk quickly about the emerging standards test. Now, this is one part of the book that I felt I wasn't ready to sign up to immediately. So emerging standards are those claims, as I've just described, where the scientific basis isn't quite there, but there seems to be some evidence that action is required. And essentially what is advocated in the book is a form of what is called the use of a harm assessment exercise that is based on German constitutional law, but is roughly recognizable in the common law as the balancing test that's used when considering to give an interlocutory injunction. So namely, if an emerging standard of some sort, where there's evidence that harm could arise, is made out as plausible prima facie to the court should do this. It should assume that the risk that the emerging view posits is true, and then go on to ask itself whether the harm of doing nothing would outweigh the harm of the regulatory intervention that the claimant is seeking. So if this sounds a lot like the precautionary principle, Dr. Tile spends a lot of time saying it is not the precautionary principle. But essentially, we're asked to assume that the risk is true and then say, would the harms of that risk materializing outweigh the harms of the regulatory intervention? Now I have some skepticism here. And one reason is that an interlocutory injunction test is something the courts can be a bit more lax on it, because the issues tend to be localized to the parties in the dispute in the conventional case. If it's on a major public policy question, the case will be heard very quickly. So the social costs in an injunction situation are fairly low. But here the scenario is different. The remedy is permanent and not interlocutory, as far as I can tell. And the calculations are so complex that the balancing exercise will be very challenging epistemically. To run the test with an issue like nuclear energy or industrial development will expose how difficult some of those standards are. So I personally wonder whether some more needs to be said in your defense of this part of your book, Dr. Tile, by perhaps bolting on some sort of further comments about the role of judicial deference or the kind of legal standard the courts would use in this situation. So I have a third comment, but I'm going to reserve that for the discussion later. And I'm thinking that Professor Liz Fisher might address my third comment anyway. I'll stop there and thank the author again for the wonderful book, and also the Bonavero Institute for the chance to talk about it. Thank you.
Thanks, Jeff. That was great. I'm now going to hand over to Liz.
Now, can people hear me? Can you hear me, Jeff? I can see you.
I can hear you loud and clear.
Okay, your ending sort of makes me feel like, what is the issue that I'm going to deal with? But I'm not going to talk about that. I'm going to start with 3 confessions. So the first confession is I love a good cover. And this has got a great cover. And so I have been thinking over the past couple of weeks, what do the turtles represent? Now, as Jeff rightly pointed out, this is not a book about rights of the environment. This is about human rights. So the turtles must stand in for something. Are we the turtles? That could be something. Or I thought each turtle could be a case of the ECHR. So we tend to think of the classic human rights environment case is Lopez Ostra. That's in the middle. But as Stefan rightly points out in the book, Dr. S, this turtle up here, could be the case. So there are different ways we could see it. So that's my first confession. My second confession is if you want to annoy me, call me an environmentalist or an environmental activist. We tend to think of environmental law as a kind of political ideology. But as Stefan also points out through his inductive survey in this book, is the importance of autonomy, environmental autonomy, is a constant theme in ECHR case law. It is something, because actually if we don't think about our sewage, if we don't think about air quality, that is something that affects us all. It's not just an ideological question. And that brings me to my third confession. I'm not actually a human rights lawyer, and I'm not a public international lawyer. I'm an administrative lawyer. And I'm an administrative lawyer who works in regimes where there isn't really much in the way of human rights. And as Stefan rightly points out, this is not a book about environmental law. This is a book about human rights and how we think about environmental protection in it. So my initial thing is, what do I have to say? Well, on the 15th of September, the Administrative Court, in a case called Richards and the Environment Agency, had done a really interesting decision about human rights and rotten egg smells. And so I thought what I'd do is I'd talk about that case, give you a brief overview of that case, and what I see is 4 issues that rise and which we might want to kind of discuss. So Richards and the Environment Agency concerns a 5-year-old boy who lives near a wastefill site up near Newcastle. Now, during lockdown, enforcement on waste disposal sites has been lax. And what that has meant is things that usually wouldn't go into such sites have been going into such sites, and that has been causing hydrogen sulfide sort of emissions. Now, hydrogen sulfide I've described as rotten egg smell. That might sound kind of funny. But actually, acute exposure to rotten egg smells actually can cause death. Chronic exposure over a long period of time is likely to cause a raised range of health risks. Now, in relation to this 5-year-old boy, the issue was that he was born prematurely, he had severe lung problems, and it would seem, I'm hearing a buzzing. Is that my fault? No, we're all okay. Okay.
Let you know if there's a worry.
Okay, fantastic. So, this was causing lung, and the exposure to this, his doctor said, was actually causing more serious kind of health problems for him, which actually would probably shorten his life. So that's the factual scenario. The argument put before the case was that the Environment Agency and the state was in breach of Article 2 and Article 8 of the ECHR, and that there should be a remedy to kind of deal with that. Now, what I think is really interesting in the analysis of the case is I can see Stefan's environmental minimum at work. So his framework, and that's not surprising, because what I think is really interesting about Stefan's book, as Jeff has already highlighted, it's both a kind of normative account, but it's also a bottom-up account from the case law. And so his account from the case law we can see in the reasoning of this case. But as I said, I want to highlight kind of 4 interesting issues that emerge in the case. The first is a set of issues about who is the victim and when is the harm. So what we see in these environmental cases is, so this case in a sense becomes a case because we have this very vulnerable victim who has problems which most of the rest of the population wouldn't have. And that does raise an issue about when we're talking about specific risk, who in the population we are talking about, and the relevance of that will become clear in a moment. Likewise, in these cases, we are talking about harm at different points in time. In actual fact, in this case, it's the harm at that point in time because of those emissions which will have future effects. A lot of human rights cases, we're talking about the past, or in cases like Neuberger, the German Constitutional Court, in relation to climate change, is talking about future generations. So there's an interesting issue here about time. So that's my first point. My second point, and this becomes clear in this case, is that in the environmental minimum, science is doing a lot of heavy lifting. The question about whether there is a specific risk and what kind of established or emerging standards are there. Now, if I was, and of course this is a field that I've worked in for a long time, this is where it gets incredibly complex. So in the case of Richards, if we look at standards for hydrogen sulfide, there are a range of different standards that exist at different levels. Acute exposure, long-term exposure, the World Health Organization, the Environment Agency, the EPA and the US. We have all these kind of different standards for different amounts, registered in different ways. But in the case, we also have experts before the court who are arguing for other standards. And by the way, this is a great case where they use hot tubbing. If you don't know what that is, we can talk about it in discussion, but not in a hot tub. So what we see is that there are all these kind of scientific questions about, well, what is the standard? Now, in cases like climate change, that's been avoided because the IPCC has been regarded as the standard. But in most other areas, we are dealing with a range of different standards. And the question is, well, which standard is the right standard? The third point that we see in this case is that when we're thinking about standards and what actually the state is doing, we are thinking about a regulatory thicket of different types of action. So in this case, we have the legislation, we have the Environment Agency as an expert institution regulating, we have guidelines that they have produced for how they regulate it, we have the permit, we have the lockdown. We also have Public Health England as a separate institution also providing advice. So in thinking about the standards, we're thinking about all that complexity. Now, that brings me to the fourth point, the remedies. So in this case, Justice Fordham doesn't actually find that there is a breach of Article 2 or Article 8. But he does make a declaration. So he says, look, the court has thousands of pages of materials, and yet there is no document before the court which is a plan. And he says, so it's not appropriate, and he says it seems that the agency is trying to do the right thing. It's not appropriate for this court to say that there is a current breach by the Environment Agency of its legal obligations. What matters from this court is clarity as to what the Environmental Agency's legal obligations are and what the Environment Agency in law must do. And that's what he does. So he gives this kind of declaration. Now, of course, this case is on appeal, as I understand it, to the Court of Appeal, and it'll be interesting to see what happens. But again, this point is what is, we think, the remedy is incredibly complex. Okay. So let me finish up. Let me return to my three confessions. So what about those turtles? Maybe the turtles, which are all vulnerable, if you know anything about turtles, represents the vulnerabilities and the complexities of each case as they must sail on the seas of kind of legal realities. On the point of kind of, my concern of being called an environmentalist, as I said, what is, I think, really valuable in this book is it lays bare this kind of environment minimum that we see in human rights case law. And I think it's important to see it in that case context. And finally, while I'm not a human rights lawyer and I'm not a public international lawyer, I think this book highlights the importance of human rights lawyers and administrative lawyers talking to each other. Thank you very much.
Thanks, Liz. That's great. Nick.
Well, good afternoon, everybody. I don't know if you noticed there, but there was a slight buzzing noise at certain parts of the talk. I want to reassure you, if you hear a low droning sound in the next 10 minutes, that's me. That's not a technical problem. I really enjoyed Stefan's book. I think it's a great book. Congratulations, Stefan. I think it's an outstanding contribution to constitutional scholarship. As Jeff says, it tackles one of the most pressing problems of our time, and it does so from a constitutional perspective. And as I was reading the book, I was thinking that it's interesting that until quite recently, constitutional scholarship didn't have much space, really, for environmental concerns. It wasn't interested in the environment. And I thought, well, I wondered why this was. And I think it's perhaps because in the past, constitutional lawyers have thought of the environment as a given. It's something that's just there, that the state rests on. So the relationship between the state and the environment is a sort of dividing up, chopping up and allocating to people. Whereas now, with the threats that we see to the environment, we see that the environment is underpinning the state, it's supporting the state, it's something that the state needs. And I think this is perhaps Stefan's greatest achievement in the book. He reorientates constitutional scholarship. He gives it a new focus. In Stefan's book, the threats to the environment cease to be things that the state manages and becomes a threat to the state and to the objectives of the state itself. The nature of the danger is so severe that it's elevated to the constitutional level. At the core of Stefan's book is a claim that I think must be right. So I think the core of the book must be correct. To oversimplify vastly, and Jeff gave us a very strong, detailed discussion of the book, but to be really simplistic, what Stefan is arguing for is that there is a human right to a minimum environmental standard. And I think, taken at its most extreme, there must be such a right because everything else depends upon it. Providing you buy into the idea of human rights at all, then a human right to a minimum environmental standard is a necessary prerequisite to enjoying anything else. Taken at its most extreme, Stefan, I think your right is the same as the right to life. You have to have it before you can do anything else. The book is powerfully argued and beautifully written. It's exceptionally well researched, showing a grasp of both law and theory. But it's not my job to be nice. When Kate invites me to these book launches and seminars, I'm relied upon to be the one to ask nasty questions. And I have 3 questions that I want to push Stefan on. First, I wanted to know a bit more about the connection between the analysis of the right in the first half of the book and the discussion of the law in the second half of the book. So these are the 2 moving parts of the book, and I wanted to know how those 2 moving parts, those 2 cogs, interconnected. Initially, reading probably far too quickly, I thought the argument was going to be, here is the human right, part 1. Part 2, here are a bunch of legal systems that more or less realise that human right, and we can judge the extent to which they failed or succeeded. But I wondered if this was how Stefan saw the project, because I'm not sure it is. I wondered if it was instead a sort of Dworkinian best reading of legal orders. I wondered if what Stefan was doing was saying that in the first part of the book, here's an attractive right, and in the second part of the book was saying, here are some legal systems that are properly interpreted, respect that right in a Dworkinian sense. The best reading of those systems is one that respects the right. Stefan, do you want to push down that path, I wonder? Because presumably that would mean that there were some legal orders that you can't interpret in a way that can accommodate that right, and the right is therefore not relevant to those legal orders. And also, if we took it that way, I suppose it wouldn't be open to us to say that there was a legal order that didn't have legal protection for that right, but still found protection for the minimum content of the environmental standard elsewhere through political processes. So I wonder, Stefan, how you would deal with the claim that there might be a system which had no legal protection for the minimum standard, but still did a great job because politics succeeded in protecting these rights. Second, and I think this was the point that most intrigued me, I wondered who the rights holders were. Wondered who the rights holders were, whether they were those of us alive today or generations as yet unborn in the, as it were, pending train of existence. Stefan discusses the place of future generations in the book, but again, I want to push him a bit further on this. The tests he uses to trigger the right, tests of threats to human dignity and autonomy, combined with some standard of risk that those things would be imperiled, seems to me to vary dramatically depending on how far into the future we can project that right. So, for example, for my generation, I think the dangers of climate change are reasonably modest. Don't all leap on me, but I think that there's a decent chance I'll live out my life in comfort, autonomy and dignity without climate change impacting on me. But I think that the chances of somebody born 10 years from now, 50 years from now, enjoying that same luxury are vanishingly thin, vanishingly small. So the risk to unborn generations of an environmental problem might be enormous. The risk to generations here today might be minuscule. And it could be then that the right to environmental minimum suddenly explodes outwards, because there are going to be an awful lot of things that are a very, very serious threat projected 100 years, 200 years on, but are of minimal threat to those of us sitting here in the room today. Similarly, I wondered how Stefan would accommodate that challenge of projecting risk into the future, and how he would then accommodate societal changes and technological changes into this. What might seem to us to be not a world worth living in, sort of sci-fi dystopia, like The Matrix or something like that, might be seem to be a terrible fate for us, but for our descendants might be normal. Yeah? So it could be 100 years from now, the idea that you have to stay inside all the time won't seem odd or peculiar or frightening. It'll be normal, commonplace and acceptable. So how do we accommodate that? How do we also accommodate the wild optimists, the people who a generation ago said climate change wasn't happening, but who now say, okay, it is happening, but we're all going to be fine because we're going to invent a way to solve the problem. To some extent, they must be right. We will discover new technologies that will abate these environmental challenges. How do we factor in, as it were, against the risks of harm, the chances of change? Thirdly and finally, Stefan focuses on the impact to dignity and autonomy as the triggers for the right. So there's some degree of impact on those two things that then generates the right to come forwards. As I've said, if we took this in the most extreme form, I think Stefan's right to a minimum standard would collapse into something like a right to life. So the most extreme form of environmental threat would be if I took all the air out of this room. And that would certainly violate Stefan's minimum. But I'm pretty sure Stefan thinks it's something richer and stronger than that. But how far can we go? And I wondered a bit about whether dignity and autonomy really were quite strong enough for what I suspect Stefan wants to do. I remember at one point in the book, Stefan, you talked about Beijing with the smog and everybody being stuck inside. And I've been in Beijing with the smog, and I've been reasonably stuck inside up to a point, but I was fine. I was still having a good time. I was meeting up with friends, I was eating food, I was reading books. So I don't think it really got to the level of my autonomy being impaired, even though I would agree with you, it got to the level at which perhaps we might legitimately say, no, this is actually a threat to people's well-being and to their lives in some way. So I wondered if we needed a richer standard about the quality of life a person is entitled to enjoy that goes beyond dignity and autonomy to give this right some teeth. But like I say, Kate drafts me into to be mean. I don't want to end on a mean note. I thought it was an excellent book. It made me think. It made me look at my subject, constitutional law, in a different way. And I think that's an enormous achievement, Stefan. It's a great book. Thank you.
Thanks very much, Nick. So now we're going to turn over to Stefan to give him an opportunity. I can see you've been making notes there to respond. Thanks, Stefan.
Right, thank you, everyone. I hope everyone can hear me okay. First of all, I think, and this is, I think, one of the proudest moments, I think, of this whole book launch has been to see the reflections of these tremendous scholars that I respect very deeply, whose scholarship has influenced and shaped the way that this book came together in myriad of ways. And hearing them engage with the book and liking some things of it and challenging me on other things has been probably the proudest moment that I think I've ever been as an academic. So thank you very much to Liz, to Nick, and to Jeff. It's been really, this book in many ways has many influences, but the core influences I think you see today represented here in many ways. You've all given me a lot to think about, unfortunately a bit too much for me to respond to in the 10 or 15 minutes that I have, but I'll try to do justice to at least some of the comments that you've kindly made and some of the feedback that you've kindly offered. So Jeff mentioned, and I'll take it in order, I think. So Jeff mentioned there was a resort questions, or had questions about the resort to minimalism. Is the environmental minimum actually as minimalistic as it seems to be when on the first blush of the book, perhaps? Or is it actually a Trojan horse? Is it something that I'm using as an instrument in order to actually impose quite onerous obligations on states? And worst of all, especially to some people in the British legal scholarship, I'm having it imposed through courts. That's one of the worst things I could possibly do. I think in many ways it is both. I think it is the environmental minimum is quite uncompromising when it comes to the rule of law. So if there are standards on the books, if the states have taken on international obligations, if they have decided to provide certain standards within their own laws for airborne particles, for greenhouse gas emissions, for these kinds of things, then yes, absolutely. I think there's no good argument that I can see that would say, okay, we need to be flexible here. We need to give states a certain benefit of the doubt when it comes to the standards that they've imposed on themselves. I think that's, for me, that's a non-starter. I think that's not something that would work. So in that case, in that sense, it can be quite uncompromising, and I definitely see the tendency of my book towards doing that, but I feel comfortable with that, I think, to a considerable extent. It gets more challenging, I think Jeff is right, and it gets especially challenging once I move on to the emerging standards, I think. The established standards can go either way, I think, but the emerging standards are the ones that are really tricky and really difficult to justify. I have to confess I need to think a bit more deeply about the comments that Jeff made about how that actually works and whether that is ultimately a convincing way of approaching, and whether it does actually elevate a certain set of standards that don't necessarily have full-throated support in the scientific community to the level of something that will be enforced through courts, because Jeff, I think, is right that there is a significant difference between an interlocutory judgment and something that you would elevate to the standards. I suppose the way that I currently see it is that this is a bit of a holding pattern. It is supposed to give individuals an opportunity to trigger the review of a court based on human rights, but it is probably not, in most cases, going to lead them to the results that they want, because the states often will have reasonable excuses for deciding a case one way or the other. But yeah, this is something I need to think about more deeply, I think, and especially the emerging standards is, I think, the most difficult one to justify ultimately. Turning to Liz, I also like a good book cover, and I especially like turtles. So maybe this is one of those situations where the picture lends itself to being interpreted in many ways, but actually I just saw turtles and I was like, this is great. I have to go with that. But yes, you're right. Science does do a whole lot of heavy lifting, and I think these projects, especially these book projects, are really only ever abandoned. I think they're never actually perfected. There's always more than you could say, and if I got my hands on it today again and took another crack at it, there's a good chance that I think it would change one or two things at least. But that being said, scientific evidence is supposed to be doing a whole lot of heavy lifting, and I'm not unconscious of the fact that this is asking quite a bit of courts. This is not something that courts, I think, are habitually doing, at least not in the sense that they are invited to evaluate, as you say, differing standards by equally qualified scientific bodies who all have slightly different views about how one should work. I think glyphosate is one of those good examples that kind of lends itself well to that. So that's a herbicide essentially. That's being used quite commonly. Its commercial name is Roundup, and it's being used quite commonly in agriculture and commercial agriculture. Now there were several different scientific bodies from several different countries take different views on whether or not it's actually a carcinogen, whether we should be banning it or not. So Colombia, for instance, banned the glyphosate, the widespread spraying of glyphosate as a herbicide. Other countries have taken a different view. And this kind of points you to one of the big issues here. So who do we believe? What kind of science do we ultimately rely on? And how do we find this elusive community of scientists who are working in the relevant fields? That can be really tricky. But ultimately, I think, while courts might be not great judges at deciding whether or not a scientific standard A is better than a scientific standard B, they might be quite good at determining whether there is a reasonable uncertainty based on the evidence before them. And I think there's ways to support courts in order to take up this test. It does do quite a bit of work, but I think there might be ways around that, even though I don't think I've really thought this through to do justice to Liz's objection, which is something that I think my book needs to contend with if it is going to be ultimately present a successful argument. Remedies, yeah, remedies is another one of those things, and those will heavily depend. I have a whole section on remedies in the book. It will heavily depend on the nature of the court. So you can easily see the difference between an international court administering an international human rights protection regime, like the ECHR, for instance, being very, very limited in the remedies that it can actually ultimately offer. So they might be able to offer individuals damages. They might be able to make declarations to the effect that the domestic legal order needs to change somehow or needs to address this issue in some way, but they won't be able to go much further than that. Contrast that perhaps with a court of the stature of the German Constitutional Court with very wide-ranging abilities to influence and to guide policy and to ultimately even make binding orders on the legislature, putting up parameters as to how and when they're supposed to legislate. That can produce vastly different outcomes depending on which court you were able to approach and what kind of remedy you were able to get ultimately. But the book is not primarily about that. Well, I think the point that I was mostly trying to make is I was trying to say that courts have the ability, as to the point that they're adjudicating human rights, they have the ability to make these decisions based on environmental harm, and they can say something, and they can say something meaningful that hopefully guides regulation better than it currently does, because what I'm currently observing mostly is a lot of very high-level commitments to environmental human rights, to the notions of environmental protection in constitutions and in international treaties and in other places. But what I'm not really seeing is that this really impacts regulatory practice on the ground. And I think Liz is right. That is mostly because we don't talk that much to each other. We have the very high-level things, and you can see that very recently. The UN Human Rights Council just recently passed a resolution endorsing the human right to an environment of a certain quality. That's good, and that's a very helpful development, but ultimately it doesn't mean much if that doesn't translate into any real practical consequences when it comes to environmental regulation. So my question for evaluating perhaps whether a legal system can deal with these environmental issues well is less whether they've put a nice programmatic line in their constitution or in their international treaty, but rather whether they are willing to contemplate reversing the standard of proof in a civil litigation. So we can think of asbestos, for instance, as a good example here. Are legal systems willing to actually do that? Are they willing to make these changes that actually make a difference to the way that contracts are struck and to the way that liability works and the way that actually shifts cost from those that pollute to the ones that suffer the consequences? That's, I think, where the main work of this is. So I don't necessarily see the remedies coming in a way top-down from a court. I'm just trying to add their voices to the toolbox, the regulatory toolbox, and hopefully that these programmatic lines ultimately make a difference. Turning to Nick's very thoughtful comments. Unfortunately, again, I don't think I can do justice to all of them in the short time that I have, but I don't think I'm Dorquinian, I'm sorry. I don't think that ultimately, I don't want to say that a legal system that is incapable or that does not interpret rights in a certain way is deficient by a standard that I've arbitrarily set. But what I would say is that a legal system that does not realize the environmental consequences and the environmental consequences for its human rights protection regime that flow from its commitments to human dignity and autonomy, I think that seriously draws into question their commitment to human rights. Now, all three speakers rightly push me on, I think, one of the most salient examples of environmental harm that is currently making the news and that is in in many ways being considered by legal scholars as well, and that's climate change. Unfortunately, I think climate change is the one area where human rights are not going to make much of a difference. And that has less to do with, I think, the theoretical argument that I'm making, and has more to do with the practice, the practical implication of that on the ground. There are unfortunately a lot of very notorious polluters, states I mean, on the planet. And they do not, for the most part, care very much whether or not they are practically complying with human rights obligations. That is an unfortunate reality. I wish it were different. So I think human rights can make a difference in countries that take their human rights obligations seriously. I think that accounts for still most of the members of the European Union, at least. That definitely is true of Britain. I think to a point, it might also be true of other states in Latin America. It is probably also true for Canada and these types of, but not to miss the elephant in the room, I don't think the People's Republic of China, under its current government, cares a whole lot whether or not its environmental obligations or environmental regulation is in line with human rights obligations. They might have other reasons to care about it. And they might have other reasons to support global efforts to tackle climate change, but they, I don't think, are based on human rights. So I find it hard to see how human rights could be or would be on neither here nor there in that kind of a debate. I think what tackling climate change ultimately requires is, I think, clever negotiations. It will require political horse trading, even if we find that objectionable, especially people who are environmentalists will find that objectionable, but that's where we are. I think we need practical compromises, and we need them quite quickly. And I think this legal process that I've outlined is a longer process. It will take a while, and I don't think human rights are the answer here. I think probably not even legal answers are the answer here. I think what will mostly do the trick is good international negotiations and cooperation, and then the legal standards can follow from that. They can enforce what's been decided, but I don't think they will actually be the thing that pushes us over the line. Thank you so much again to all three commentators. I was very, very grateful for you to be here, and yeah, I look forward to some interesting questions. Thank you.
Great. Thanks, Stefan. Okay, we're now going to turn it open to the floor, and just to remind you, we are operating hybrid today, or at least I hope we are. So we might have some questions that are coming in through the feed, which guys we will put to us, but we also have roving mics. So please just put up your hand if you've got something. We've got about 25 minutes. And if you could just introduce yourself as well at the beginning. Thanks, Country.
Thank you very much. I'm a visiting professor from Canada. Thank you very much for mentioning Canada. I'd like to pick up on Nick's focus on the right to life. As you know, the Dutch Supreme Court has used the right to life to produce a very powerful remedy in terms of the 25% reduction of emissions, which was, I think, totally unexpected by so many people around the world. And that was followed up by another Dutch court at a micro level in terms of the pollution by the Royal Dutch Company, focusing on the local environment, where they added to this concept of the right to life the duty of care on the part of the company. And I think that, and I agree with Nick's view, that goes beyond the minimalist to actually start producing a very powerful set of standards which can go beyond a minimalist thing. And the Dutch Supreme Court added to that the whole idea of, if you accept the right to life as the fundamental protections, you also then have to deal with the legal right to protect. And from that could flow all the other things, such as, how do you do that? What are the reasonable steps you can take? Which fits in again with the duty of care idea of proximate cause, reasonable foreseeability, and a whole bunch of quasi-legal standards which can build on the right to life. So I was wondering if you can add on to what you've decided, this richer concept of the right to life.
Thank you. I'm wondering if we should take one or two
Okay.
others.
Yeah,
Are there other questions? Yes, Shreya. I see several. Okay, so we'll take
Thanks,
three,
Greg.
or maybe I see four if you can manage,
That's
and then
fine,
we'll
yeah.
go. Shreya,
I'll
thank
take
you.
notes.
Thanks, Stefan, and congratulations for the excellent book. I can't wait to get hold of a copy, and I feel like asking a question at a book launch, the answer is, well, get a copy of the book. But I feel like you can give us a primer.
Yeah.
On the human rights aspect, I was wondering if you think there are certain kinds of human rights which have an intimate link with the environmental minimum. And I ask that because the assumption in international human rights law, perhaps a wrong one, is that civil political rights have an inviolable core versus the language of minimum is perhaps more attractive or more used in socioeconomic rights. And I was wondering how you compare right to life, prohibition of torture, Article 8 rights, so Article 2, 3, and 8 of the ECHR in comparison to, say, rights in ICSA, so right to health and right to science. And I wonder what the implications of locating the environmental with respect to not just these specific rights, but the dichotomies of civil, political, and socioeconomic rights are. Thanks.
Thanks, Shreya. And then there was a question just behind you. Yes?
Thank you. Rajiv Shah did the PhD at the same time as Stefan, and I had the role of being the defender of the political constitution, giving him objections. So I'll continue that fine tradition. Stefan, I think for your first set of standards, current legal standards that state has signed up to, you've got a good answer to the sort of legitimacy challenge, which is, well, their legal standards, stay signed up to them, so yeah, they've got to follow through. But for the second category of sort of environmental standards that are widely accepted but haven't yet been converted to legal standards, presumably states had an opportunity to convert those into legal standards, for example, at the next COP conference. And these happen fairly regularly, so it's not like amendments to the US Constitution where it's very hard to do. That's something that happens quite regularly. So presumably they haven't chosen to yet turn those into legal standards. So where does the legitimacy to turn those into legal standards through environmental minimum comes from?
Thank you. Now I think I saw Ewan behind you. Ewan?
Thank you, Ewan Smith from the Institute. First of all, thank you all very much for your presentation, and thank you especially, Stefan, for the book. I want to pick up on something you said about China at the very end of your response and connect it to something that Jeff said earlier on. One of the challenges that you would face applying these standards in a state like China is the human rights framing. Another obvious challenge is the judicial framing, which Jeff touched on in respect to the public policy elements of this. But it strikes me that the tools that you've put in the toolkit would be highly appropriate for an internal administrative law. They'd be the sort of tools that, for example, the Communist Party, which is committed to an ecological civilization, but which struggles to get its junior officials to employ those rules and those decisions when they deal with granular issues in front of them. They are the sort of rules that I think would empower officials in China rather than undermine them. Could you maybe say a little bit more about how these ideas might be amplified through an internal administrative law rather than how they might be cabined by judges or used by judges?
Thanks. Stefan.
Oh, thank you. I'll do my best to do all of those questions justice, and thank you for the questions. Yeah, the Dutch rulings. I'm not super optimistic about them, I have to say. I think there's two peculiarities, one peculiarity, and especially in the Dutch legal system that makes them quite interesting. So the first is that there is no domestic enforceable Bill of Rights in the Netherlands. So they have to resort to the standards of the European Convention on Human Rights. And so it is interesting, no doubt, to see a Dutch court relying on standards within the ECHR to say, look, this is a problem. You guys need to fulfill your obligations in terms of the 25% reduction target. And yes, under domestic tort law, there is this obligation of the Royal Dutch Shell Company to reduce its emissions. The two problems that I see with that and why I resisted a similar way of thinking about the environment in my book was that the democratic process matters, right? So I'm not opposed in the outcomes. I think those outcomes are fine. I think that's actually consistent, which I think is important. But I don't think that such a deeply complicated issue that will probably require sacrifices of all of us across all, literally virtually all societal areas, is necessarily apt for a definitive resolution through a court. Where I think the court have a role to play, and what I think they should be insisting on, is first and foremost, that those standards that have been adopted are actually complied with. I think that's the first and most important thing. And the second one is that compelling scientific evidence isn't ignored just because it's not politically opportune to act on it, right? So I think I'm thinking especially of air pollution when I think about that standard, right? So World Health Organization has recently revised its air pollution standards, and it's fair to say significantly tightened them. Even before they did that, there was virtually no major city on this planet that was complying with those standards. I think that's a major problem, especially since we know the health effects that can have. So I think that's where the role of the courts is the most powerful, to kind of nudge the policy process towards not ignoring these issues. On the Dutch shell company itself, I think there is value in it, and this is exactly the kind of thing that I'm hoping that eventually flows from this kind of recognition of human rights standards in towards environmental harm, that individual liability throws from that. So another piece of my research that's not in the book is about how certain powerful private actors, I think, are subject to human rights obligations quite directly. So I think that's where it could flow from, where it could come in, where there could be a fruitful thing. But I'm a bit more careful about imposing that on the political process itself. Shreya, yeah. I get really annoyed with the distinction between civil and political rights and social economic rights. I think it's historically understandable, given where human rights come from, and there's swaths, as you know, of critical theory written about where they came from and whose interests were prioritized and whose were considered to be of less value and less important in the process. But I think there's no, and then this is where I'm with Jeff, I don't think there's not any meaningful theoretical distinction between those two, in the sense that we could say that the one is more important than the other and we need to trade off the social and economic rights versus the political. I get really annoyed by bad takes that usually revolve around something like, well, civil and political rights impose strong obligations on the state, and social and economic rights are only, do the best you can, and then and that's all fine. I think that's nonsense. I think we can be much more nuanced about it. There's certainly some rights, I think, where we could say, yes, there is a certain progressive element to it, and states need to fulfill that one step at a time, and that's fine. But I don't really see a good argument for that with a lot of other socio and economic rights. So I don't accept that distinction. I don't think it's really meaningful. I think it's a bit of a dead end in legal scholarship, actually. Following from that, I don't really make a distinction between that in my book either. It is really just about any right really can be impacted, conceivably at least, by environmental harm of a sufficient severity. And any right will do, really. So if it is within the context of the ECHR, the most likely candidates are Article 2 and Article 8. It might also be procedural. It might be a 6 or a 13 violation. So that kind of things could definitely come in and trigger those obligations. If it's in a different system with a different doctrine on certain rights, it could definitely also be others. I actually think that the civil and political rights, the classic ones anyway, have surprisingly little purchase on this question. I think it's actually just about the foundational aspects and commitments that human rights represent as a whole. And I think that's where it sort of comes from. However that a legal system that we examine conceptualizes that will do. I don't think I don't think we should be very picky about it, essentially. Rajiv, thank you so much for that. Yeah, the legitimacy challenge grows. The further you move away from the established standards down to the emerging ones, the stronger the legitimacy challenge potentially gets. I think that's completely right. I think I would defend the established standards because, at the very least, in the administrative laws that I'm familiar with, and that's the UK and that's Germany, it is not good enough to simply ignore advisory opinions. You can obviously take a different view, and within the bounds of reasonableness and proportionality analysis, you can definitely take a different view. But it's not good enough to just say, well, scientists, the overwhelming majority of the scientific community is telling me that the threshold value for, I don't know, for particles of 2.5 microns in the air should be this. I just don't think that's right. I don't think that's enough. I don't think that's just disagreeing with that standard. I don't think should be enough. And I think we should ask. And that can be both a political and a legal answer. I'm not even saying that this is an entirely just a legal thing, but a part of the answer is definitely to challenge this on a legal basis, to say, well, what makes you think that not regulating certain harmful particles, substances, is appropriate? And states have a relatively easy out, I think. So the only thing that they would really have to do in order to avoid the application of quite, to avoid an adverse judicial ruling, for instance, would be to actually just regulate that, put it into regulation, and make sure that you actually enforce it, and then there's probably not going to be an issue. But that's obviously also cuts a different way in the political sphere. So I think those elements can go together, but I think the legalistic one, which is what I'm focusing on in the book, I think would definitely push towards that. I think you can defend it. I think there are ways to defend that. Ewan, yeah, thank you very much for that question. Yes, I think actually there is a big sphere of application beyond the courts, and that just focuses on the administrative practices of officials. I think there's actually quite a bit of scope for that. So the reason that I say that is that what I identified in a subsequent chapter, which to be fair is not at the foreground of the book, but identify 3 pathologies that I think historically have plagued the way that we regulate environmental issues. I think the first problem that we have is political lag. So we have a certain basis of scientific evidence, and then there's an understandable lag between that and actually putting that into any sort of regulation. There's always going to be that kind of lag. That's not necessarily in and of itself a problem, but it leads to a situation where powerful economic actors especially, and I think that would probably resonate to an extent at least also in China, can take advantage of an empty regulatory space. They can set up their practices, they can set up their business model, and they can start making money that way. And that then entrenches a certain way of doing things, right? And so one way I think in order to be more responsive to some of these concerns, you don't necessarily have to enforce that through a court. That can also actually happen on an administrative level as such. You could say, well, okay, we have a certain obligation in order to ensure that the scientific standards that we actually do draw upon are enforced within a certain time frame from being clarified and being adopted, right? So I think it definitely lends itself to that. I would say that it's not the primary mechanism that I envision, but I think there's aspects of the minimum that will work in that way as well. So yeah, hopefully there's something in there for everyone. I certainly don't mean to discriminate on the basis of the legal and prevailing legal and societal system in any country, but I definitely think there's more purchase to the ideas that I make in a system that generally respects human rights.
Great, thanks, Stefan. Just looking at Gayatri to see if there are any online questions, are there? Yeah, do you want to put it? Thank you.
So one of our online attendees asks, what, in your opinion, is the most challenging feature of climate change for constitutional judges? And the second question is, watching the Richards case, it struck me that the 2 experts were not equipped to answer some kinds of scientific questions which the judge was interested in. Is there a way this could be improved, especially for cases which might affect large numbers of people?
And I'm just going to see if there's anybody else in the audience who's got a question. Anybody else who's got a question? Yes, I see. Okay. We'll take these 3 here, and then we're going to wind up. And Stefan, we're going to ask you to be to the point.
Yes.
Thanks, Matthias.
My name is Matthias Malmann. Hello. Just a pretty technical question about what courts can do. I just wanted to follow up. One way to see it is to say that what courts can do is to check whether the legislator is conforming to legally given aims. So let's say prior as a court sets certain limits, so the court can control that. Or could you derive something that goes beyond that, some kind of freestanding standard derived from a human rights position? The one is, in a way, an accessory control. The other one is a more powerful tool to intervene in legislatory processes. Thank you.
Thanks, Matthias. And then just behind you, yes, thank you.
Thanks. I wonder if you see a relationship between the principle of non-regression and progression, and I guess the threshold of the environmental minimum. And I don't know if it's maybe as a moving, sort of like a moving target. I don't know if this was the point of Professor Barber on, like, in the context of climate change.
Thank you. And then the last question here.
Hi, AJ Hudson. I'm a DPhil in the geography school and a JD from America. So I guess I kind of wanted to ask, in which ways does your theory kind of wrestle with concepts of of the subhuman and of who is given human rights. I think that often we envision human rights as being maybe most important for marginalized groups, yet in reality, it is marginalized groups who are often the least likely and the first excluded. And I'm thinking both in terms of ethnic minorities like the Uyghurs, or also xenophobia like undocumented immigrants in the United States, to whom minimum wage, minimum labor requirements, like throughout the world you just see none of the minimums apply to certain people. And there's actually, it ends up kind of reinforcing this kind of quiet apartheid, right? And so I guess I'm wondering, how do you wrestle with that concept, and in what ways could we make sure that the environmental minimum doesn't just fall into the same kind of hidden framework that we see environmental justice and climate justice is already telling us there's two worlds that you can live in? And how do we make sure it's for both people of both worlds?
Great, thank you. Challenging aspects of climate change for courts. I don't quite, I have to interpret that question, or maybe you want to clarify. I don't quite remember where that first question came from.
I think it was constitutional.
Constitutional courts, sorry, yeah, there we go. Thank you, that makes more sense now. Thank you. I think the biggest challenge for constitutional courts is one that Nick actually threw into the mix, and that is, how do you conceptualize the effects that climate change is going to have, for instance, on future generations in the current context of the people who are alive right now. So I think the German court wrestles with that a bit. I'm not 100% convinced by the framing, but I think one way of doing it is to say, okay, well, you have a certain burden that needs to be met. You need to do certain things in order to avert climate change, and those burdens need to be shared equitably across the generations. And that's perhaps one way of approaching that. That is, I think, the biggest issue. I don't think that's quite solved yet. There's some, I quibble, I'm writing a case not on it right now, but I'm quibbling a bit with the German court on a couple of things there. I don't think it quite works yet, but that is a potential route forward for a constitutional court, I would say. On the Richards case, I'm sorry, I'm not super familiar with it, but do you want to jump in?
Can I just jump in?
Yeah.
So I think an important thing to remember in all of this is, to me, and it would be interesting, to me the environmental minimum is a reminder that really human rights law is a backstop on all of this. You know, it is actually environmental law which is dealing with these questions all the time, which is doing a lot of the work. But the value of your argument is showing it's the backstop. Now, in that, courts are not actually deciding on the science themselves. They are reviewing institutional discretion. And so one quibble I would have, I don't like the word scientific evidence, because it suggests it's a case for the court. Likewise, it's not really about burdens of proof. That's something we use in courts to decide in civil cases. This is reviewing the institutional competence, the administrative competence of the decision maker. And that, of course, requires the court not just to understand what are the questions, but also what is the institution, what is the legislation, how do they all interact? Sorry.
Yeah, no, that's a very good point, I think. And that probably also answers the Richards point to a significant extent, yeah, definitely. So, but sorry, I'm not familiar with that case specifically. Yeah, can we go beyond enforcing certain legal aims? Yes, but again, I think I have to stick with what was just said. I think the issue for me is more what the environmental minimum that I'm developing really tries to tackle is regulatory inertia. It's trying to tackle the situation where a regulator has decided that for whatever reason it's not politically opportune, or it's not convenient, or whatever, or they just don't have the resources to regulate a certain environmental harm that is harming people currently. I think that's what it's mostly trying to do. I don't think I want to be a lot more prescriptive than that, because I think actually on the whole, and I have empirical evidence to back that up to an extent, those European states of the Council of Europe that are also members of the European Union, which has quite a tight environmental regulatory regime in many respects, actually do a whole lot better on their human rights record when it comes to environmental rights as well, right? So there's a noticeable difference between the success rate of applicants when they're challenging a decision by a state that is in the Council of Europe but outside of the EU versus one that is in the EU. So I think actually if you let this process work, there's a good deliberative process at the EU level, for instance, already. If you let that process work and if you apply that regulation more consistently and enforce it, then actually I think the process is pretty good. I don't actually quibble with the environmental regulatory side so much as I quibble with the idea that we can just leave certain things unregulated because it's inconvenient. And I think that is one of the bigger issues that I actually see currently. Yeah, non-regression in the environmental minimum. A quick answer to that, yes, it does feature that. One of the big tests for whether or not a regulation was enacted in good faith is whether or not it's retrogressive. So if there's a case from Sweden where the regulatory threshold value for, for arsenic in drinking water was regulated downwards. So the threshold value was X, and then it was X plus 2. So basically, they just changed it and they increased it for whatever reason. That was completely against the scientific evidence at the time. There was no good reason to do it, apart from wanting to avoid certain regulatory obligations that would befall them. So that, I think, is a very clear-cut example of bad faith legislation. So yes, it does feature. How do I wrestle with the issues of marginalized groups and for other reasons not being able to access human rights in the same way as others? In short, the book doesn't. My personal view on this is that human rights are an aspirational principle, are aspirational principles that we hope to reach and that we hope to realize in full in societies that care about human rights, but I'm under no illusion that that is not presently the case in most societies that we know. That doesn't mean that there aren't societies that do a worse job at it and some societies that try to do a better job at it, but ultimately what the environmental minimum specifically tries to do, it can't solve those problems, those underlying societal problems. I think the only thing that it can hope to do is to give willing regulators, willing states, and willing governments the push towards actually dealing with environmental harm more consistently. So it's a very humble hope in the end, I think. I'm sorry I can't offer more than that.
Great. Well, thanks, Stefan. And I'd just like to conclude by thanking our panelists for being here, Jeff, who's on the screen, and Liz and Nick for great commentary on the book. And finally, of course, a big thanks and congratulations to Stefan. And thanks as well to our team, Greg and Gayatri in particular, but also the others at the Bonavera who've made this possible. We find hybrid events still the more difficult of the events that we run. So thanks very much, Gayatri and Greg, for making it work so well this evening. Yeah. Please do join us for a glass of wine outside before you go. It would be good to get a chance to chat and catch up. Thanks very much indeed.